This is a great treat for us, particularly on behalf of the Carr Center, to welcome Juan Mendez to the Kennedy School of Government. It's good to see some of our familiar, loyal supporters back in the room, and it's very exciting for us as the Center to be able to move back from some of the concerns which have been top of the agenda for many of you over the last few weeks. In other words, social movements, Afghanistan and Pakistan, Turkey and the Balkans, or even trafficking, and to return to what has often been the lifeblood of the Carr Center since its very beginning, in other words, the discussion of genocide. This is following on from a long tradition which is represented initially by Samantha Power and by Mike Ignatieff, now very strongly by Sarah Sewell. Some of you have participated in her mass atrocity response program, looking at what the US military might be able to do to prevent genocide. And this, of course, is a subject on which Juan Mendez is a great expert, because he was the special advisor to Kofi Annan on genocide and prevention of genocide. And he's also someone we're very proud to welcome because he's a very unique combination of a human rights practitioner and scholar. He ran an important center at Notre Dame University, but he was also himself a prisoner of conscience in Argentina in the 1970s, was one of the founding members of Human Rights Watch, was the chair of the president of the International Commission on Transitional Justice, which many of you know, and helped to lead many of its programs in over 30 countries around the world dealing with issues of transitional justice. So in these reflections on genocide, we're drawing on somebody with a very direct and concrete life experience. So welcome, and over to Juan. This event will finish just before 2:45 for those of you who are worried. And I think a couple of people in the audience have spoken to me to say they'll have to leave early. One person is teaching, for example, so of course that's fine. But thank you so much for coming, and over to Juan.
Thank you very much, Rory. It's a real pleasure for me to be here. It's quite an honor to be invited by the Carr Center for Human Rights and to speak at the Kennedy School of Government and at Harvard University. So I don't have to belabor the point. I am very proud to be here, and particularly to talk to you about this area of human rights practice and of international relations practice that has become almost well, certainly a fascination, but almost an obsession with me since Kofi Annan asked me to be his first special advisor on the prevention of genocide. But quite frankly, in all of these... Sure.
Is that true? I'm not sure.
Is it better?
Yeah.
As a member of the human rights movement, I have to say that prevention of human rights violations has been something that has preoccupied the human rights movement for a long time. And at the same time, it's clear that we have found a very sophisticated and increasingly very effective way of reacting to human rights violations once they happen. And although we've always been concerned with how do we stop them from happening in the first place, the fact is that for a variety of reasons that has not been an easy task. I suppose one of the main reasons is that it's very difficult to predict human events under any circumstances, but also because for the human rights movement, especially when it was being formed, it was very important to try to avoid the risk of falling into ideological traps and being too quick to stigmatize and condemn a government that was considered by some not friendly or even an enemy without the situation having reached a moment in which the concern could be realized. And also because, quite frankly, the more that we thought about indicators of deteriorating human rights conditions, many of them are indicators that were present in situations not only that would not lead to mass, gross and consistent patterns of human rights violations, but that were in and of themselves legitimate tools that some governments could, under international law, avail themselves of if they were fighting, for example, a violent insurgency. For example, many very serious human rights violations happen in the context of states of emergency, but the declaration of a state of emergency is by itself not illegal, not illegitimate under international law. And quite frankly, because there was no empirical evidence to show that any kind of preventive action that we might be able to take beyond warning of impending doom was in and of itself effective in stopping the deterioration of human rights violations into something worse. Now that, of course, applies in spades to prevention of genocide and other mass atrocities. And yet the international community cannot avoid the important duty and responsibility to try to prevent genocide from happening. And that's why the lessons learned in the human rights movement have to be applied, especially for the United Nations, but also for other organs of the international community, and particularly after the signal failures in the 90s to prevent the genocide in Rwanda and in Srebrenica. And it was the task of preventing genocide became even more urgent after that, and especially as studies conducted to see what had gone wrong signaled deficiencies in the structure of the United Nations as to that made it difficult to prevent human genocide from happening, even if you knew that there were signs and there were signals and indicators that should have warned of what was going to happen. And that's why the United Nations created in 2004 the Office of the Special Advisor on the Prevention of Genocide, and later in 2007 another Office of the Special Advisor on the Responsibility to Protect. And it's building little by little a sort of capacity, or hopefully a capacity, to prevent genocide and other mass atrocities from taking place in the first place. And I stress another mass atrocities because one of the main problems that we had is that because genocide has a very precise definition in international law, as we saw in the case of Darfur, we spent endless debates about whether what was going on the ground in Darfur amounted to genocide or didn't amount to genocide, without concentrating on what needed to happen to prevent whatever was going to happen from happening, whether it was or would have been genocide in the end or not. I think simultaneous with this debate, the human rights movement has developed another very interesting facet of its work, and that is the demand for accountability for human rights violations that have already occurred. It's an important task of the human rights movement, and I would say that the whole human rights movement now is focused on how do you confront legacies of very serious human rights abuses at a time when it is possible to confront them because the country is undergoing a transition from dictatorship to democracy or from conflict to peace. And the societal exercises of making sure that egregious human rights violations do not go unpunished have yielded important emerging norms in international law about the duties of states to break the cycle of impunity for these human rights violations. Those emerging norms are now very widely accepted, and I won't go into detail about how they emerge, but I do want to say that they are reflected in the creation of the special criminal tribunals for Rwanda and for the former Yugoslavia, later with the creation of mixed courts in Sierra Leone, in Cambodia, and I think especially in 1998 we get the turning point in the approval of the statute, the Rome Statute, for the creation of the International Criminal Court. All of these development in very quick succession and in only a few years shows a definite turn towards the obligation to investigate, prosecute, and punish egregious human rights violations by the territorial state certainly, but by the international community as well, when the territorial state is unwilling or unable to do so. I have to say that the pursuit of justice is justice for its own sake. It's justice for the value that justice has, and because we recognize that the victims of these very serious abuses have a right to see justice done. Nevertheless, we put faith on the fact that justice will also have some kind of preventive effect about future violations. In fact, the reason to erect these barriers against impunity has a lot to do with prevention. And not from the last few years. Even at Nuremberg, we had the reason for creating the Nuremberg Tribunal was precisely not to let the Holocaust and the war crimes of World War II happen again. The same premise that justice, prosecution, and punishment will have a preventive effect is in the Genocide Convention of 1948, more recently in the Convention Against Torture, in the most recent Convention Against Forced Disappearances, and especially, as I mentioned before, in the Rome Statute. The purpose of creating these mechanisms of justice is precisely to have a preventive effect. Unfortunately, at the same time, we don't have any empirical evidence that by prosecuting and punishing we will prevent future human rights violations, but we do have the expectation, and I would say even the promise, that these actions that we take with a lot of difficulty today will have a preventive effect in the future. We are rightly skeptical of the fact that penalty by itself prevents future violations. It doesn't happen with homicide, for example. It doesn't happen with rape. Why should it happen with genocide? But we also know from criminology that the only thing that seems to have some kind of preventive effect is the certainty of punishment. And precisely in international law, what we don't have is a certainty of punishment. We have more the certainty of impunity than the certainty of punishment. And from human rights practice, this may be more impressionistic, but I think we can say that we know that the reverse argument is true, that impunity does breed more violations, does create the impetus for new violations and encourages repetition of the violations that we're concerned with. So justice has to be a part of the tool of prevention if we're going to have prevention of serious mass atrocities. But we have to recognize that it may be a tool to prevent violations from happening in very different situations, though that relationship is even more difficult to prove empirically. At the very least, it is preventive of escalation of the human rights violations that have already happened in the same scenario and by the same actors. For example, in Darfur, it's very clear to me that the impunity for the crimes committed by the Janjaweed and by the government of Khartoum is just another factor in making it very difficult for the international community to come to lasting solutions in Darfur. And the literature is full of examples. Genocide and mass atrocities always recognize previous episodes of very serious human rights violations. The grievances remain unsolved and resolved, and therefore it just becomes a breeding ground for new violations. Impunity emboldens the perpetrators to commit more atrocities and perhaps even to up the ante and commit even more serious atrocities because they think they can get away with it. It also encourages the victims to take matters in their own hands, so the risk of escalation of the conflict while impunity remains is very high. And it prolongs the instability and the dependence on the international community's aid. It prevents victims, especially when they are displaced and living in IDP camps, they prevent them from making rational decisions about return to the villages, about decisions about property, about and particularly about participating in the solutions to the problem that they are victims of. And if they are only seen as victims, their participation is crucial to lasting solutions to the conflict. I saw this firsthand in Darfur in 2004 during my first visit there, together with the United Nations High Commissioner for Human Rights at that time, Louise Arbour. We could tell that impunity was a leading factor in the instability, despite some progress that we did see in some other areas. Like, for example, in 2004, the international community had quickly reverted the situation of humanitarian aid and was eliminating famine as a threat. And the African Union was already making some progress in protecting people from further harm. But the impunity was itself one of the more significant factors of instability. And that's why when we returned and briefed the Security Council, we called for an end to impunity, and we were among the first ones to call for a referral of the case of Darfur to the International Criminal Court. In light of the fact that although we had asked very carefully, there had been no action whatsoever by the domestic jurisdiction on any of the 200,000 or more persons who had been killed in 2003 and 2004, nothing on the 400 or plus villages that had been decimated in those years as well. In fact, prosecutors that we talked to just gave us puzzled looks as to why they hadn't even opened a file on any of those things. So after April of 2005, as you know, when the Security Council did refer the case of Darfur to the ICC, and after the International Commission of Inquiry, chaired by Professor Antonio Cassese, had actually recommended that referral as well, then for months and maybe even for years, there was complete silence by the international community on the fact that the government of Sudan was rejecting any sort or refusing to give any sort of cooperation to the Office of the Prosecutor of the ICC. I tried to call the attention that the government of Sudan was getting away with defying binding resolution taken by the Security Council under Chapter 7 of the Charter, that is basically in pursuit of peace and security of nations, and that therefore Khartoum should not be allowed to get away with that defiance. In 2005, I visited Sudan again, and I made a very public call for cooperation with the investigations of the International Criminal Court. As a result of that, when I returned, this time they didn't let me brief the Security Council. Some members of the Security Council refused to let me brief, which was a real setback for the Office of the Special Advisor that had been created precisely at the behest of the Security Council. And if the Security Council didn't want to hear what the Special Advisor had to say after a very recent trip, you can imagine how defeatist that position is and how negative for the future of prevention by the Secretariat. Unfortunately, 5 years later, I think impunity is even worse today than it was then, because the government of Sudan doesn't even pretend to be investigating the crimes of 2003, 2004, and the intervening crimes as well, because there have been many of them. The conflict is now spreading to other parts of Sudan and perhaps getting worse. It may be true that the mortality is less now, and the pace of mortality at least is slower now than it was in 2005, but the conflict is far from over, and there are 3 million people dependent completely on everything that the international community can give them for assistance, etc. And there's no effort by the international community to break that dependency by forcing the hand of the government in Sudan to allow for more serious resolution of the conflict. In the meantime, the situation with justice has become even worse because there's very lukewarm support for the ICC after the arrest warrant issued against President al-Bashir. there's been invocations or attempts to invoke Article 16 of the Rome Statute, which would allow the Security Council to suspend the activities of the ICC in Sudan for a year, renewable several times. There's been a proposed criminal jurisdiction for the newly created African Court of Human and People's Rights. It's not even in effect yet, but they're already talking about giving it criminal jurisdiction. And there's been threats to create a wave of African denunciations of the Rome Statute in protest. Mostly all of this has been bravado and nothing has happened, and that's good. That seems to be, to me at least, that the international community has called the bluff of Sudan and its allies, and that the catastrophic predictions that of what was going to happen if Bashir was indicted or ordered arrest have not materialized. But nevertheless, the fate of the international community in the International Criminal Court as an instrument of both peace and justice has been badly shaken, and we don't really know what the ultimate consequences of this would be. I have to stress that justice in this context is an ingredient of prevention, but it can never be the only one. In my experience as the special advisor, learning first from Darfur but applying it to other parts of the world as well, I came to the conclusion, and I said so publicly, that we need to act simultaneously and in an integrated fashion in 4 areas, and in each of them to adjust the measures to the changing situations on the ground. One of them is accountability, and I've already talked quite a bit about it already. But the other one is protection, and by that I mean physical, armed protection of people who are at risk because of their ethnicity, religion, national origin, etc. And that means deployment of contingents, police or military contingents, to protect them. The third is humanitarian assistance, because people are vulnerable in many different ways, and the first thing that needs to happen is to make them less vulnerable to famine and to health concerns because of the position they have been put in by the actions of, in this case, of the government. And the fourth is trying to solve the underlying conflict by peace negotiations that are serious, that are well managed, and that go in the right direction. But it's important that we conceive of these 4 areas as actions that we have to take simultaneously and in integrated and coordinated fashion. And how do we integrate them? That's a real serious problem, and of course solutions will depend on the situation on the ground at any given time. But one thing that we can say from the start is that we cannot allow any one of them to become the condition for progress in the other 3. By this I mean, for example, what happened precisely again in Darfur in the months and even more than, maybe even a year leading to the so-called Darfur Peace Accord of 2006. Because during that time, the government of Sudan refused to make any concessions on protection, on humanitarian assistance, and on accountability, certainly, saying that all of it was going to fall into place after the rebels and the Khartoum regime reached an accord in the peace talks. The fact is that the Darfur Peace Accord came and went. It didn't solve any problem. It was not even a peace because the majority of the rebel forces didn't even sign on to it. And Khartoum read it more as a formula for new action rather than as a peace process. It did not feel obliged to do anything about peace, and instead went on to attack and to try to resolve the situation by military means, thereby creating even more instability. The fact is that we need, in Darfur, the consent of the government of Sudan, and in many other places, the consent of the territorial state for many actions that the international community has to take. We have to make sure that that consent is not manipulated by the relevant territorial government, as it has happened and continues to happen in Darfur, where the government of Sudan consents to the presence of the African Union and then grounds their airplanes by just denying them fuel, for example, and constantly plays games with visas and with permits for importation of materiel, etc. That kind of manipulation is something that will happen in other situations as well. And here is where we have to have a larger view of the political will of the international community to act. Because more often than not, we think of political will in terms of whether to send troops or not in a non-consensual situation. That, of course, in some cases will be absolutely necessary. But what's important is to see the lack of political will to engage in serious, consistent, systematic, and permanent pressure on recalcitrant governments like the Khartoum regime to abide by compromises and by commitments that it has made to the international community from time to time. I think the lack of political will in the case of Darfur is reflected in this off and on attention that the international community has paid to Darfur that has allowed the Khartoum regime that is there 24 hours a day and 7 days a week thinking about how to thwart the international community's response has allowed that government to manipulate its consent to appear to be negotiating with the international community when in fact all it does is to contain the legitimate concerns of the international community. This brings me to the responsibility to protect, and in the next 5 minutes I promise I'll stop. When the doctrine of responsibility to protect, or the principle of responsibility to protect, was adopted in 2005 during a summit of heads of states of around the world that took place in the context of the General Assembly in the United Nations, it came out of nowhere in the sense that the document that was supposed to create a blueprint for the reform of the United Nations was generally very disappointing almost in every aspect of it except for this. And this, the language that it used, borrowing from several different incarnations of the responsibility to protect, was startlingly simple and easy to understand. And the fact that it was approved unanimously by 180 or 190 states represented and 80 or 90 or maybe even 100 heads of state being present there should have given us a sense that we had achieved a major new commitment by the international community on the responsibility to protect. And the language was very easily acceptable to nations in the north and the south and the east and in the west, because it starts with the responsibility of the territorial state to protect its people. And in the second instance, if the territorial state is willing but unable to protect, then the international community has a duty to come to the assistance of that willing but unable state to protect the citizens. And only in the third stage, when the territorial state or its government is unwilling to protect vulnerable populations at risk, then the responsibility shifts to the international community to protect those populations at risk. But even in that third stage, the document very clearly calls for a number of actions that are not necessarily limited to non-consensual use of force. Although obviously non-consensual use of force has to remain in the toolkit because unfortunately in some situations it is the only thing that will save lives and prevent genocide from happening. But in the meantime, there are many things that the international community can and should be doing that are accurately reflected in the responsibility to protect. The enemies of responsibility to protect, or the people, some states that are doing pushback on it, call it humanitarian intervention by other names. Humanitarian intervention was, very quickly discredited in the 90s by the debacle of Somalia and several other places. But there's a big difference between that doctrine and this one. In humanitarian intervention basically focuses only on a non-consensual use of force, and it's a it's a doctrine that legitimizes unilateral interventions or interventions by coalitions of the willing outside the normal channels of decision-making in the international community. The responsibility to protect, on the contrary, stresses, on the one hand, that all these decisions have to be adopted to the normal channels adopted by international law, and two, that there's many things that can and should be done before engaging in non-consensual use of force. Status of the responsibility to protect is, some of us think that it is a norm already of international relations. Even one of its proponents, the high-level panel on challenges and threats, called it an emerging norm before 2005. So you would think that with the adoption in 2005 and with everything that has happened, that the emerging norm may have crystallized as a norm already. But there's a lot of pushback on it, and so much pushback that it motivated a very serious debate back in July in the General Assembly of the United Nations. And the pushback basically tries to make it seem that it's either that it's not a norm at all, it will never be, or that we are still in very early stages of it becoming ever a norm. So that's not something that can be resolved, and certainly won't be resolved by a resolution of the General Assembly anytime soon. So the other possibility is of considering it a doctrine, and in that sense a doctrine that organizes the work and the planning of the Secretariat of the United Nations for the future. I think in that sense it can be a very useful tool. The problem is that all this debate that has happened since 2005 has basically had the effect of preventing the possibility of development of the tools that will make responsibility to protect operational. And I'm sorry to use jargon on you, but that's operationalizing R2P is the buzzword in the United Nations today. In order to operationalize the responsibility to protect, what we need to do is to have a serious system of early warning and of early action. And here again, we will face those who say, well, we had warning of Rwanda, we had warning of Srebrenica, we even had people armed there on the ground, and we still didn't stop them. Nevertheless, I think early warning is very important, because if you have it and if it operates regularly and you resist the pressures of states that don't want to be named, etc., and you actually do an objective follow-through of situations that are tending to deteriorate, it generates the possibilities of political will that is never there to begin with. We know from experience that political will doesn't appear spontaneously, that it has to be created, that it has to be shaped. In fact, the most interesting illustration of how it is shaped is in Samantha Power's book about Rwanda, A Problem from Hell. That the fact that political will has to be created behooves us to understand how it is created and what can we do to create it. And certainly in different countries it has to be done by different people, by different organizations of civil society, by different leaders. But at the international level, it can depend on the ability of the Secretariat to have an ongoing monitoring effort of early warning combined with important and feasible suggestions for early action that can then generate it's going to be a lot easier to generate political will at an early stage than a much later stage when everything else has failed. So I think that creation of mechanisms and development of tools, both for early action and for early warning and for early action, is the great difficulty of our time. We have the offices of the Special Advisor on Prevention of Genocide and of Responsibility to Protect. They have a little more resources now than they had when they were first created, but what needs to happen in the Secretariat, and is not happening, is a creation of a culture of prevention. By that I mean that anybody doing his work in DPKO or in DPA or in the Office of the High Commissioner for Human Rights in Geneva and learns of something that seems to be going in the wrong direction should have the immediate reaction to alert these offices and other people in charge of these things to act through early warning that is in itself a form of action, but also to come up with ideas about what could happen. Right now it doesn't happen. The office of the special advisor gets his or her calls returned, certainly. But the flow of information and analysis and advice to that office doesn't happen. It goes only in one direction and not in the other. That's what I mean by a culture of prevention. There's been 10 or 15 years of exercises of prevention of conflict, but it hasn't yet gelled into a culture of prevention, and especially not of prevention of mass atrocities within the Secretariat. And just borrowing a word from the General Assembly debate this last summer about responsibility to protect, and I was very encouraged by that debate because although we all felt that the debate was going in the wrong direction, in fact the majority of the states that took the floor defended the responsibility to protect and insisted on it. And very few really objected to its terms, to its nature, to whether to make it operational or not. Borrowing then a phrase oft repeated during that debate that took a couple of days, that it's not the time to discuss responsibility to protect, it's not the time to discuss prevention of genocide and mass atrocities, it's a time to implement. Thank you.
Just gonna shout because my microphone is stuck. No, don't worry. Okay, so firstly, thank you very much. Just to begin the conversation, your analysis is obviously rooted within the bureaucratic legal structure of the United Nations and the human rights legislation associated with the United Nations. And sometimes there's a suggestion that over maybe the last 5 to 10 years, that model is beginning to be eroded, that the United Nations doesn't look so strong, that the international community in general appears to lack knowledge, lack power, lack legitimacy, that countries like Sudan appear to have the potential to resist intervention in different ways, through nationalism, through portraying the international community as colonialist, through raising the specter of Islam or religious objections to intervention. And so I suppose I would be worried, looking at this whole R2P thing, about whether this can actually work, because, haunted by the failures in places like Sudan, looking at the mess in places like Iraq and Afghanistan, the United Nations is tempted to say, well, this of course is just that we haven't operationalized properly, we haven't got the right kind of procedures in place, there are too many coalitions willing, we haven't got the right kind of legitimating staff. But in fact, one's tempted to say, no, in historical terms, that isn't really the problem. The problem here is that in a battle for legitimacy, the international community always looks more weaker. Here's the lack the political weight that even a dangerous country like Sudan appears to be able to deploy. And so that the popularity of, Alex de la Wall or someone in Sudan saying, oh no, all this stuff about prosecuting Bashar al-Assad fails to reflect the reality of tribal structures in Sudan and the political necessities of these kinds of negotiations. So I wondered what you could offer us as a kind of positive case study or something where you could make us see in practice to alleviate my doubts, to restore my faith in this system.
Well, that's a very tall order to restore your faith in the system. I have to confess to my own, concerns about the weakness of the international architecture the way it is right now. On the other hand, it's the only thing we have. And quite frankly, coalitions of the willing are just not going to be around if there are no other interests. The humanitarian impulse by itself is not going to do it, so we do need the bureaucracy. We do need the structure in place to generate the political will that is often lacking. And at the same time, we also need that to restore our faith in the workings of international law the way it's supposed to work. I am convinced that or I'm hoping at least that the delegitimation of the international community and of international law that has happened in the last 8 or 10 years, its inability to stop invasions of countries without any kind of justification, and even when everybody who was looking knew that the justifications were mendacious, to say the least. I'm hoping that that's not something that will stay with us for a long, long time. I'm hoping that better heads will prevail, and that we will, you know, understand the needs for international law and for the regular ways of adopting solutions to crises through mechanisms that are there. That's not to say that they shouldn't be improved upon, but I don't think, for example, we can allow the responsibility to protect and prevention of mass atrocities to be hostage to the reform of the Security Council, because then that's never going to happen either. And I think the countries that objected to the responsibility to protect because the Security Council is undemocratic, they really had a secondary intention. I mean, they don't want to reform the Security Council as much as they want to make sure that the international community does not intervene in situations in which their view of sovereignty should predominate. But you asked me for some more positive examples, and after making this very, you know, after agreeing with you with the really low level of legitimacy that the international architecture of decision-making currently has, I would have to say, one, that Alex Deval and Julie Flint and others were wrong in predicting the kind of catastrophes if we let international justice work. And that's not to say that we should be satisfied, but I think, in fact, the arrest warrant for Bashir will be seen for its effect in prevention as we go forward. We will see it when Bashir himself becomes so isolated that he's no longer the main spoiler of the situation in Darfur. And quite frankly, I think that Bashir is the problem, not the solution. And that's why I think it's important to isolate him, to push for replacements of Bashir within the decision-making structure of the government of Sudan. And if you do it by setting off an arrest warrant against him, I think that's a very practical way of doing it. Obviously, what we need is some kind of political will to enforce the decisions of the ICC. And there, I completely agree that we are in very, very early stages of that. Unfortunately, even among the like-minded states that created the ICC to begin with, the political will is wavering. I mean, they have all kinds of competing interests. It's very understandable. But when it comes to, you know, enforcing decisions of the International Criminal Tribunal, Criminal Court, it seems like they are, you know, willing to make concessions to other interests that may prevent them from doing so. So the ICC is weak. It's obviously, we always knew that it was going to be weak when it only started. But turning to maybe a more positive example, let me just point out one in which the threat of prosecution may have helped, and that's the situation in Côte d'Ivoire in 2004, when the situation was really getting out of hand, and during a weekend, the government of Mr. Gbagbo fired the director of radio and television and put someone who, in 2 days, generated the most incredible amount of hate speech and incitement to commit atrocities that you could ever think of, very reminiscent to people who were there of Vladimir Colin in in Rwanda. And at that point, I asked the Secretary General, and he asked the Security Council, and very quickly there was a resolution pointing out basically that the ICC that did have jurisdiction over Côte d'Ivoire from 2002, that the jurisdiction of the ICC including not only genocide, crimes against humanity, and on war crimes, but also the incitement to commit them, and that somebody who was inciting could see himself, put under the jurisdiction of the ICC. At the same time, a situation, I mean, not to insist too much on why it was so dangerous, but there were militias armed in the countryside of Côte d'Ivoire, willing to work on behalf of the government at the least attention to it. And there were marauding gangs of what they called young patriots, also in favor of the government, that were going around the city of Abidjan, breaking windows, etc. They could easily have turned against Europeans and against the so-called non-Ivoirian citizens of Côte d'Ivoire. The situation was very, very dangerous, and it was kind of diffused precisely because the advisors to President Gbagbo and to the rebels who were holding the north, they realized that in fact the threat was not completely idle, that in fact some people could be found to be prosecuted by the ICC, and they called the hate speech, they called it off. Situation, for a variety of reasons, remained very difficult for a year or so, but the fact is that today Côte d'Ivoire is not in the brink of genocide, is not in the brink of mass atrocities, and it may well be that justice there, just the threat of prosecution, may have played a preventive role. I don't want to make too much of it because it could have been, it has to do a lot with the circumstances on the ground, particularly with a really very good special representative of the Secretary General on the ground, Ambassador Pierre Sharif from Sweden, who was really savvy and intelligent and knew how to play his cards very well. But the fact that he could, give the lead to the rest of us in New York at the appropriate time and in urgent fashion, and we all reacted positively, and we had the ICC to threaten with, may have prevented a catastrophe that we would all be lamenting otherwise today.
Thank you very much. Please. Yeah.
You mentioned the use of hybrid courts in Sierra Leone and at other points. The Mbeki high-level panel on Darfur gave their report and recommendation to the African Peace and Security Council last Thursday, and they want to be implementing a mechanism for a hybrid court in Darfur at a time when the amendments to the Sudanese judiciary that is supposed to come under the 2005 CPA haven't been put into place. What is your view? You've spoken about the ICC addressing the issue of impunity, and you've also spoken about the government of Sudan hasn't been addressing the issue domestically. But don't we need truly accountable Sudanese courts with a reform of the Sudanese judiciary in order to deal with these issues? Or how do you see it from your framework, through your experience at the UN, and seeing the successes of hybrid courts in other...
I'm very much in favor of hybrid or mixed courts. So far the experiences have been very good. But there are as many hybrid courts as there are courts, because they're all different from each other in different ways. But the Sierra Leone court, the special court for Sierra Leone, is an excellent example. In East Timor, there was a very good exercise as well. The one for Cambodia, I mean, we all have our doubts, but we have to let it work itself out. With respect to the Thabo Mbeki suggestion, I mean, I was initially very skeptical because it seemed to me as just another maneuver to undermine the ICC. But in fact, a mixed court and putting the burden on the domestic jurisdiction to do its part to break the cycle of impunity is a very good idea. It's such a good idea that Sudan has rejected it already. I mean, mean, unfortunately, it's not going to go very far, but you can tell that it was a good idea because the government of Sudan wants nothing to do with it. Nevertheless, I completely agree that we have to insist in the best case scenario, and not only in Sudan but anywhere, the International Criminal Court will deal with 4 or 5 cases, and that's all that we can probably aspire to. They also have by regulation, they have to deal only with those bearing the highest responsibility for atrocities. And therefore, a lot of mid-level decision makers, some very important ones, would go scot-free if there's no other possibilities of doing it. Even the proper concept of complementarity is not that either domestic jurisdiction or the ICC acts, but that they both act, and that they both act complementing each other. And so if the domestic jurisdiction has to be assisted by a mixed court kind, I completely agree with it. That kind of idea is coming forward in Kenya, for example, where there's most of the Kenyan civil society is so completely skeptical that the Kenyan judiciary can come up with serious courts or serious prosecutions, that they only want the ICC to operate. But even they recognize that the ICC will have jurisdiction and could only operate just to scratch the surface of what happened in Kenya. So the effort now is to create a serious domestic court, if possible with assistance from the outside, which is more or less a definition of a mixed court, depending on which model you use. And yes, I think even universal jurisdiction should play a part, although it's very discredited now with many different attempts to use universal jurisdiction in Europe. But I think, quite frankly, the creation of the ICC was never premised on substituting for either domestic or for other forms of international community support for justice. And if it's going to work preventively, if it's going to have a stabilizing effect that can lead to peace and not just to justice, it probably has to be in a coordinated fashion with domestic, international, and mixed international and domestic jurisdictions.
In the question about trying to find something positive out of these gloomy discussions, Juan, perhaps what is your comment on the fact that we did have a strenuous discussion in July of R2P, and it's still in the process of being worked. The UN will continue. Is it possible to say that we do have a norm that has emerged, and that it's one which will increasingly be employed in the background? And then the question is how to employ it frontally. The Security Council tried to do that just the other day with Guinea, and Russia vetoed the attempt to bring Guinea to account. So is the question the large powers, China and Russia, or is there something else which we should think about?
Well, I actually feel encouraged by the debate about R2P, because it seems to me that, I mean, I was discouraged by the fact that we even had to have the debate, because I would have thought that the outcome document would have clinched the question of whether we have a norm or not. But if it was inevitable, I think we got the best out of the debate that we could have gotten. I think the Special Advisor on Responsibility to Protect produced a great document for the Secretary General, and the debate was framed in a way in which the enemies of R2P were not able to get their way. So I think, in fact, we do have a norm. I mean, whether I think it's already a crystallized norm or an emerging norm, it doesn't really matter that much, because we'll never know for sure. There's no organ of the United Nations that will say it is a norm or it isn't. But but I think it's enough of a principle, at least, that can be used to orient and organize the action of the Secretariat first and of the other organs of the United Nations later. In the meantime, we do have the problem of of vetoes in the Security Council. As you know, the document of the high-level panel recommended that veto should not be used in cases of genocide or mass atrocities. And that discussion was revived during the General Assembly discussion, and it's up in the air again. I see a major difficulty in implementing it because I can see a state that has the veto saying, well, yeah, I promise not to use the veto, but this is not genocide, therefore I'm using it. Right? And so it's kind of circular. It's very difficult to know how it's going to work in practice. But the fact that there is the pressure to not let vetoes become the obstacle to intervention based on the protection of life of vulnerable populations is already by itself an important element that goes in the direction of being able to do better, if not perfectly, do better than we've done in the 90s.
Yes, I would like to come back to the question of the domestic level that you mentioned. And it has to do with how situations taking place in a given continent may the momentum created by bringing perpetrators to justice can do a lot of favor. And I just wanted to take the case of Latin America, where 20 years ago we were in a very different situation, and you could say that in the last 10 years there have been like different levels of bringing perpetrators to justice, with, I would say, Argentina being in the forefront. And some people could discuss about the question of democracy and compare Argentina with Chile or others. But when you look at the balance, you see that Argentina has been pushing stronger in that direction. And that has made Chile to act as well, in Uruguay, and then even Peru, for maybe not mass atrocities, but for a number of crimes in the case of Fujimori. So how do you think? So how do you think this plays, and how can we? So it's not only the question of the International Criminal Courts. It's also how do you make this? How do you help this happen in other places?
Well, it is the Southern Cone is the part of the world where most accountability for past human rights violations is taking place today. That is taking place 30 years after the fact is not something that we should be proud of. But on the other hand, it also shows that these matters don't go away, that societies insist on them, that victims have a way of injecting their agenda into the national agenda, and that things do happen, and that they happen with complete regard for due process and fair trial is something that should be pointed out as well. It's Argentina, but I think Chile is doing as much in terms of numbers, certainly, or more than Argentina. Uruguay, the Supreme Court has just declared the amnesty laws unconstitutional, and even President Lula has just announced a truth commission for some serious events that happened in the 70s in Brazil. So, and as you pointed out, in Peru, I mean, the formerly all-powerful president, Alberto Fujimori, is already serving 3 or 4 different sentences for serious human rights abuses. So, in a way, that doesn't mean that we've broken the cycle of impunity even in those countries, but it does show a tendency and an acceptance by society of rules of international law that are applicable to the domestic setting, and that the judiciaries of our countries are accepting as their duty. Now, I think that's an enormous example to the rest of the world, but I want to stress that it's not, Latin America, and particularly the Southern Cone, is not an isolated example. I mean, I would say even in Africa today that even if you look at the leadership of Africa, there's all kinds of wavering positions going back and forth towards being with Sudan or reaffirming the notion in the new African Union document that that there's a duty of the African community to come to the rescue of populations that are threatened. But what I think of the debates after the Bashir arrest warrant is that the civil society of Africa has come out very, very strongly in favor of accountability, of prosecution, in defense of the International Criminal Court, although not necessarily defending specific action, but defending the institution itself. And I think that doesn't mean that we don't pay attention to the weaknesses of the system of justice internationally, and perhaps even to mistakes that can be made as we operate it. But it is very heartening to see, how committed to justice and to justice as prevention is African civil society, and how it is getting its muscle together to influence their own government. I don't know if you heard, but Bashir was going to go to South Africa for Zuma's inauguration, and the civil society of South Africa petitioned the government to say in no uncertain terms that their participation in the Rome Statute meant that if Bashir arrived, he would have to be arrested. The Ministry of Justice said so, and Bashir didn't go. So Bashir can still manipulate some governments, but he's confined to traveling to governments that are not part of the Rome Statute. That, I think, is a measure of isolation that will eventually, and it's not the only example. I mean, he has tried many times now to get the Arab League to condemn the ICC, and he has not been able to do so. So even in his cultural part of the world, he doesn't carry as much power as we sometimes think he does. So,
well, thank you. Very last question, perhaps. Somebody?
Oh, I have a
you did
question,
have a
actually.
question,
Yes. This may not be a very fair question, but you spoke a lot about political will. That political will is needed, and I assume this political will is, to a great extent, a response to successful implementations of the responsibility to protect. So I was just in that context, correct me if I'm wrong, but in this context, I just wonder what would be, it's kind of late, but what would be a realistic implementation of responsibility to protect in Darfur today? And what would have been, I know, sometime prior to the U.S. invasion of Iraq? Or is...
And I'm afraid you sadly only have 3 minutes to respond.
I'll catch you after the topic.
well, I mean, I don't think Iraq was ever a situation of responsibility to protect. I mean, Saddam Hussein had committed many, many atrocities, but they were, 20 years earlier. And there were many reasons why we should all be happy that Saddam Hussein is no longer part of the picture. But I don't think it justified the unilateral or coalition of willing kind of invasion that was based on several other reasons. And I'm sorry, Razak, if I very superficially touched upon your country, and I hope you're not offended by it. But in the case of Darfur, I think we still don't have a force at the level that was approved by the Security Council in 2007. In 2.5 years ago, and we still haven't reached that. And it's part the manipulation of the Khartoum regime, but it's part the lack of political will of the international community to assist in getting Sudan to remove its annoying conditions that they have to be African they have all kinds of European forces in the south of Darfur, and suddenly they have a territorial sovereignty problem in Darfur, and they have to be only African. But also they have to abandon their restrictions on material that the rest of the world can provide the African troops that they don't have. And frankly, it's also the fault of the European Union and of the Western powers generally that have always nickel and dime that force and have not been able to fund it in the appropriate measure that it needed to reach the levels approved by the Security Council. That's why I said political will is not just a question of sending troops or not. It's a question of being mindful of how we exercise political, diplomatic, and all kinds of other decision-making processes by which we get, step by step, we get the solutions that we need, and then we go to the next step. And I think, unfortunately, we were in a better shape to protect people in Darfur in 2004 than we are now, and it's unacceptable. We cannot really accept that if we were in a position to help, we lost ground on that position for lack of resolve, for lack of political will. That I think is what I wanted to say about political will. It's not just about sending or not sending troops.
Okay, well, thank you very, very much indeed. And this has been a really magisterial account, stretching all the way from the southern cone of Latin America to the African Union, to Iraq, to the architecture of the international community, and actually a very, very powerful and very moving defense of things that can sometimes seem a little bit bureaucratic and a little bit abstract in the face of cynicism, realpolitik. So I'm very, very grateful. Thank you so much. We very much hope to see much more of Professor Mendez here at Harvard, and have everybody a very good afternoon. I look forward to seeing you soon.